I have watched rights disappear at traffic stops before, not through legislation or court decisions that made headlines, through silence, through confusion, through the assumption that cooperation means survival and assertion means guilt. A traffic stop is not a conversation. It is a legal proceeding where every word you say can be used to extend the detention, justify a search, or establish probable cause for arrest. Most people treat it like a minor inconvenience. That assumption costs thousands of Americans their freedom every year. The average traffic stop lasts between 6 and 12 minutes. But those minutes operate under constitutional rules that most drivers do not understand. The Fourth Amendment protects against unreasonable searches. The Fifth Amendment protects against self-incrimination. The Sixth Amendment guarantees the right to counsel. All three apply during a traffic stop, but none of them activate automatically. They must be invoked. And if you do not invoke them clearly, the law treats your silence as waiver. There are 4 sentences that end a traffic stop on your terms rather than the officer's terms. 4 sentences that convert a legal encounter from an open-ended investigation into a contained procedure with defined limits. Most people never say them, and by the time they realize they should have, the search has already occurred, the statements have been recorded, and the case is being built. The first sentence is, "Am I free to go?" 4 words that force the officer to make a decision they would prefer to avoid. Either the stop is over and you are being detained without reasonable suspicion, or the stop has concluded and you are free to leave. There is no third option. But most people never ask the question. They wait for permission. And while they wait, the stop continues indefinitely. The law is clear. A traffic stop is a seizure under the Fourth Amendment. It must be justified by reasonable suspicion, and last no longer than necessary to address the reason for the stop. The Supreme Court ruled in Rodriguez v. United States that police cannot extend a traffic stop beyond the time needed to handle the matter for which the stop was made unless they have reasonable suspicion of additional criminal activity. Once the officer has your license, registration, and insurance, runs your information, and writes the citation, the stop is over. Anything beyond that point is a new seizure that requires new justification. But if you do not ask whether you are free to go, the officer can extend the stop by asking unrelated questions, requesting consent to search, or calling for a drug dog. And courts will treat your continued presence as voluntary unless you clearly indicated you wanted to leave. The second sentence is, "I am invoking my Fifth Amendment right to remain silent." Not, "I don't want to talk," not, "I have nothing to say." Those phrases are ambiguous. Courts have ruled that ambiguous invocations of rights do not require police to stop questioning. The invocation must be clear and unequivocal. You must use the words that reference the constitutional right you are asserting. The Fifth Amendment protects against compelled self-incrimination, but it does not apply automatically. The Supreme Court ruled in Berghuis v. Tompkins that silence alone is not enough. You must affirmatively invoke the right, and once you invoke it, police must stop asking questions. If they continue and you answer, those answers can be used against you because the court will treat your response as a waiver of the right you just invoked. Officer asks where you're coming from. You say nothing. Officer asks where you're going. You say nothing. Officer asks if you have been drinking. You say no. That answer just waived your Fifth Amendment right. Everything you say after that point is admissible because you chose to speak after invoking silence. The third sentence is, "I want a lawyer." Not, "I think I should talk to a lawyer." Not, "Maybe I need a lawyer." The request must be clear and unambiguous. The Supreme Court ruled in Davis v. United States that if a suspect makes an ambiguous reference to an attorney, police are not required to stop questioning. They can continue. And they can use your subsequent statements even though you indicated you might want legal representation. If you are being questioned and you are not free to leave, you are entitled to request a lawyer. And once you make that request clearly, all questioning must stop. But if your request is equivocal, police can ignore it and keep asking questions until you either invoke clearly or provide incriminating answers. The fourth sentence is, "I do not consent to any searches." This must be said even if the officer is already searching. Because consent is a constantly updated status in the eyes of the law. If you never consented but the officer is searching anyway, your refusal must be on record or courts will assume you acquiesced. The Fourth Amendment protects against unreasonable searches, but consent makes any search reasonable. If you give permission, the officer does not need a warrant, probable cause, or reasonable suspicion. Your consent eliminates every constitutional protection that would otherwise apply, and courts define consent broadly. Silence can be consent. Hesitation followed by compliance can be consent. Physical cooperation during a search can be consent. The only way to preserve your Fourth Amendment claim is to refuse consent clearly and repeatedly, and even then, the officer can search if they have probable cause. But if they search without your consent and without legal justification, the evidence can be suppressed. If they search with your consent, nothing can be suppressed, no matter how unreasonable the search was. These 4 sentences operate as a legal framework that converts a traffic stop from an investigatory encounter into a controlled procedure. Without them, the stop lasts as long as the officer wants. With them, the stop has defined boundaries that can be enforced in court. More than 50,000 traffic stops occur in the United States every day. That is over 18 million stops per year. And every one of those stops is a Fourth Amendment seizure where constitutional rights apply but are rarely asserted. In Rodriguez, the Supreme Court considered a case where an officer extended a traffic stop by 7 or 8 minutes to allow a drug dog to arrive. The driver had been given his citation. The officer had returned his documents, but instead of allowing the driver to leave, the officer asked for consent to search and detained the driver while waiting for the dog. The dog alerted. The search produced methamphetamine. The driver was charged and convicted. The Supreme Court reversed. They ruled that once the purpose of the stop was complete, the continued detention violated the Fourth Amendment. The 7-minute extension was unreasonable because it was not supported by reasonable suspicion of additional criminal activity. But the driver in Rodriguez did not ask if he was free to go. He waited. And during that wait, the officer extended the stop unlawfully. If the driver had asked after receiving his citation, the officer would have been forced to either release him or articulate reasonable suspicion. Instead, the driver's silence allowed the detention to continue until the violation became clear enough for the Supreme Court to intervene. In Burghuis v. Tompkins, the defendant was interrogated for 3 hours. He remained almost entirely silent, but near the end, an officer asked if he prayed to God for forgiveness for shooting the victim. The defendant said yes. That one-word answer was used to convict him of murder. The defendant argued that his 3 hours of silence should have been treated as an invocation of his Fifth Amendment right. The Supreme Court disagreed. They ruled that silence is not invocation. The defendant needed to affirmatively state that he was invoking his right to remain silent. Because he did not, police were free to continue questioning. This is the gap between what people believe their rights are and what the law actually protects. People believe that remaining silent is enough. The law requires you to announce that you are remaining silent. People believe that hesitating when asked for consent communicates refusal. The law treats hesitation as ambiguous. Traffic stops escalate through incremental expansions that seem minor in the moment but compound into detention, search, and arrest. Officer pulls you over for a broken tail light, asks where you're going. You answer. Officer asks if you have been drinking. You say no. Officer says he smells alcohol and asks you to step out. You comply. Officer asks if there's anything illegal in the vehicle. You say no. Officer asks for consent to search. You hesitate. Officer interprets hesitation as suspicious and calls for a drug dog. Dog arrives 20 minutes later. Dog alerts. Officer searches. Officer finds something. You are arrested. At what point did this stop violate your rights? The answer depends on whether you invoked them. If you asked, "Am I free to go?" after the officer returned your documents, the stop should have ended. If you said, "I'm invoking my Fifth Amendment right to remain silent," when asked where you were going, the questioning should have stopped. If you said, "I do not consent to any searches," when asked about searching the vehicle, any search without probable cause would be unlawful. But if you did none of those things, every step was legal. Your cooperation was treated as voluntary. Your answers were treated as waivers. Your hesitation was treated as suspicious rather than refusal. This is not about hostility toward police. It is about understanding that traffic stops operate under legal rules that do not align with common intuition. People assume that answering questions makes them seem cooperative. The law treats those answers as evidence. People assume that refusing a search makes them look guilty. The law treats refusal as protected and consent as waiver. The structural problem is that police benefit from ambiguity and civilians suffer from it. An officer who asks, "Do you mind if I search your car?" is not asking whether you object. They're asking for consent. If you say, "I guess not," or "Go ahead," you just consented. If you say nothing and step aside, courts may treat that as implied consent. The only response that preserves your rights is, "I do not consent to searches." These 4 sentences do not prevent police from doing their job. They establish boundaries that the Constitution already requires. Police can still write citations, they can still investigate crimes, they can still arrest people when they have probable cause. What they cannot do is extend stops indefinitely, question you after you invoke silence, continue interrogation after you request a lawyer, or search without consent or legal justification. But those protections only apply if you assert them, and most people do not. They answer questions they did not have to answer. They consent to searches they could have refused. They wait for permission to leave that they were legally entitled to demand. The consequences are not minor. A traffic stop that results in a drug charge creates a criminal record that affects employment, housing, professional licensing, and immigration status. A traffic stop that escalates to resisting arrest can result in felony charges even if the underlying stop was unlawful. Approximately 700,000 people are arrested during traffic stops every year in the United States. Many of those arrests result from evidence obtained through consent searches or statements made during extended detentions, and most of those searches and statements could have been prevented by invoking rights clearly. This is the moment where constitutional protections exist in theory but disappear in practice, not because courts have eliminated them, because civilians do not know how to activate them, and police are not required to inform you of the specific phrases that convert your rights from abstract principles into enforceable boundaries. The 4 sentences are not magic words. They are legal signals that courts recognize as invocations of constitutional protections. Without them, your silence is ambiguous, your refusal is unclear, your request for a lawyer is equivocal, and your hesitation to consent is treated as eventual agreement. The emergency is not that police are violating rights during traffic stops. The emergency is that rights are being waived during traffic stops because people do not understand that assertion requires specific language. The next encounter could be yours. The next stop could last 6 minutes or 60 minutes depending on whether you know the 4 sentences. By the time you realize you should have said them, the search will be complete and the case will be filed.